right. Appreciate you all showing up. I know we have maybe not too many new faces, but we'll, just for the purpose of the record, we'll ask the attorneys to introduce themselves. We'll start with the state.
Mike Conner, Attorney General for the state.
Mike Murray.
Brad Beckworth.
Reggie Goodman.
Abby Dilsager.
All right, and for the Teva defendants?
Nancy Patterson for the Teva activist defendants, Your Honor. Good to see you.
Thank you.
Nick Merkley for Teva activist.
All right. Mr. Lauderdale?
Mike Lauderdale for certain cities and counties.
Okay.
Your Honor, Richard Rose, on behalf of the Speaker of the House. Mark Murray, on behalf of the Governor.
Mark Burgett. Thank you, gentlemen. All right. At the June 10th status conference, I had asked General Hunter and the Teva to brief the issues that we raised at that status conference, and asked that briefing be filed June 14th with any proposed changes to the consent judgment and settlement agreement. I didn't see briefs filed on that, but I know that there was a combination application to file an amicus brief and a motion to intervene that were filed jointly by the governor, the speaker, and the pro tem with the governor's group. And then also there was a motion to intervene filed by a group of the cities led by the city of Oklahoma City, the subdivisions group. With regard to the governor and the legislature, I'm going to grant the application to file the amicus brief, and the amicus brief is deemed filed, and I appreciate them doing that. I also want to maintain the motion to intervene that's filed by the governor and the legislature on the court's docket, along with the motion to intervene that was filed by the cities. And I would direct General Hunter and Teva to file any responses that you feel you need to file to those motions within the next 2 weeks or next 15 days. That said, I know that everyone's interested in a quick resolution to this matter, and I am too. I've got this little trial that I'm in the middle of right now that's taken a lot of my time. And so I have asked former Chief Justice Stephen Taylor if he would act as a special master to work with the parties to consummate the Teva settlement. And in that regard, I've directed Justice Taylor to contact and work with General Hunter, with Teva, and the political subdivisions to hopefully get a joint proposed consent judgment and settlement agreement that can be presented to the court either before that 15-day deadline or hopefully even earlier. And so I wanted to make sure y'all understood that. As a side note, Judge Lane Phillips has been the settlement judge in this matter, and he will continue to be. He's an invaluable resource to this action. But I decided to reach out to Justice Taylor for this particular issue. So those are the announcements that I wanted to make today. I understand that there's been some back and forth between the Attorney General and the Teva defendants trying to work on some of the finer points of the settlement agreement and the consent judgment that I had mentioned. I think that's fine. But I don't think that negates the need to have a greater effort to try and bring resolution to these matters. And so that's why I'm taking this action that I am. Do any of you have any questions of the court or need any further clarification for how we move forward with this?
So, Your Honor, I would just, I guess, reiterate remarks that I made last week when this matter was before you. As Chief Law Officer of the state, I have responsibility not only to the legislature and the governor, but to the judiciary. And my efforts have been focused and directed to harmonizing those responsibilities. It seems to me that the sooner that we can get these funds directed to the state, to the benefit of the state, in an account that's segregated, the better. And so my hope would be that we could conclude this in an expeditious fashion. And with all due respect, I'm not sure that timing is in the best interest of securing these funds.
And I understand. I understand where you're coming from. You know, this is an $85 million settlement, and I think we all want to make sure that it's deposited according to the law, that it's used for the intended purposes, and so that's why, rather than rush into something, I want to make sure that we bring all the stakeholders to the table and get a final resolution that will benefit everybody. So I understand your concerns, but I still want to proceed with this route.
Thank you, Ron.
All right. Ms. Patterson or Mr. Merkley, anything you wanted to add?
No, Your Honor, I understand what you've asked us to do, and we're willing to do what you've asked us to do.
Okay.
Welcome the chance to talk to Chief Justice Taylor.
Okay, thank you. Anybody else before we get, yeah, Mr. Lauderdale, go ahead, sorry.
Judge, we're operating in a little bit of a vacuum because the settlement agreement or the proposed settlement agreement and consent decree hasn't been made available. Would it be possible through the mediation process that all parties, including us and the state and the legislature, could see what actually is being proposed?
So the amicus brief that was filed by the governor and the legislature, it purports to have the consent judgment and the settlement agreement attached as exhibits, though I did not see them in the public filing. So I don't know if it was intended to be attached, but it wasn't, but we can certainly address that issue. I know that they were, when you read the brief, it says they're attached, but I didn't see them with it. So what we can do is we can find out what the intention was and talk to both the Teva defendants and the Attorney General to see if there's any opposition to that. Mr. Rose, do you want to come on up here and
Yes, sir.
so we can all hear you?
I'll address that for you. It was the intent of the parties when we understood that there would be others filing briefs on the 14th. We did intend to attach that, believing they were going to be public documents. When there was no other briefs filed, because of the potential privacy concerns, we ended up not attaching those. That was a judgment call we made just because nobody else had made them public yet.
Okay.
So if the court orders us, we're more than happy, or whatever the general decides on that. But yeah, understand that's why they were not actually attached to our brief.
Thank you.
Governor Mack,
Sure. Yes, Jim.
Your Honor, may I be heard? I would just specifically direct the court to the language in the settlement documents, which specifically identifies the releasors as the state, specifically its agencies and departments, and the Attorney General. So with respect to political subdivisions, this settlement would not in any way, shape, or form limit or impact their interests.
Okay. Before you sit down, do you have any objection to making public the consent judgment and settlement agreement that were presented to me last week? And I'll hear from Teva too, but I want to, and maybe if you need to talk with each other, you can do
State
that.
would have no objection, Your Honor, subject to advice and consent of Teva defendants.
Sure, Ms. Patterson.
Your Honor, I would prefer not to have anything made public that has not yet been approved by the court. Now, I certainly have no objection to us sharing it with the cities and the counties and with the governor and with Justice Taylor in terms of the communication I envision you want us to have with him. But until the agreement itself is made final through your consent judgment, I prefer not to have that document made public, as there may be, I don't know what may happen, but there may be changes to that.
Now, last week at the status conference, I indicated that I would not approve any settlement agreement that wasn't attached to the consent judgment.
And we understand that, Your Honor, and we've always understood that that would be the case. So that's not my concern. I just don't know if, as a result of what may happen in the next 15 days, there may be some changes to what has
Sure.
been put in writing up to this point. I'm not trying to be cute about it at all, Your Honor. I would just
Sure.
rather it be the final document. But again, I don't have an objection to, sort of in the guise of this process that it sounds like you're wanting us to engage in, sharing it with the parties at the table here.
Then that will be my order, that the proposed consent judgment and settlement agreement be produced to the putative intervening parties, both the cities, counties, and the governor and legislature.
Certainly. No problem with that at all, Your Honor.
Okay.
Glad to do it. Thank you.
Thank you. Thank you. All right. If there's nothing else, then this time we'll excuse our Teva defendants and Mr. Lauderdale. You're welcome to stay and watch if you like.
Thank you, Your Honor.
Thank you.